Good morning. Today is Tuesday, February 5th, 2025. It's 8:30 a.m., and I'd like to call to order the meeting of the Tennessee State Board of Accountancy. Notice of the February meeting of the Tennessee State Board of Accountancy, including date, time, and location, has been properly noticed, and a copy of the agenda was posted to the Board of Accountancy website on January 27th, 2025. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet or by placing their name in the chat box online. It's requested that comments be limited to 3 minutes out of respect to others. At this time, I would ask Karen to do a roll call.
Greg Gilbert.
Present.
John Griesbeck.
Present.
Pam Church.
Present.
Sam Bennett.
Present.
Andy Bonner.
Present.
Brad Buchanan.
Present.
Brad Floyd.
Present.
Kevin Monroe.
Present.
Rob Vance.
Present.
Thank you. So I believe we have a quorum. Great. I would like to welcome all visitors and members of the public, and many of you we will hear from today at some point, so thank you for attending and welcome. As I mentioned yesterday, we are very pleased to have Jen Binkley with us. This is Jen's first official board meeting. We had committee meetings yesterday, but Jen, you have already started doing outstanding work, and thank you for being with us, and we're fortunate to have you, so thank you. As also mentioned yesterday, our newest board member, or one of our newest board members, at least, Mike Parton, attended the February meeting. We're in February today. He attended the October meeting, and that was his first board meeting, and subsequently he felt the need to resign. So the TSCPA, in accordance with our statute, will be submitting a name or names of potential candidates to sit in the chair that Mike occupied. So again, Mike is a really fun individual. I hope you got to meet him and talk with him a little bit. I've known Mike for a number of years, and he was a great addition to the board, but he will not be serving with us. So in your package was a response letter that we submitted to NASBA and actually the AICPA. As you will recall, they asked for a comment on the proposed CPA competency-based experience pathway to CPA licensure. As noted during the October 2024 meeting of the Tennessee State Board of Accountancy, our board had not reached a consensus on the proposed pathway to licensure. The board indicated at that time a desire to offer written comments and questions raised during the board meeting to NASBA and the AICPA in response to their request for comments on their open exposure drafts. Our executive director, Jen Binkley, compiled our comments from the October board meeting, and she drafted a comment letter, which I reviewed. Actually, Vice Chair John Griesbeck and I reviewed independently and offered our suggestions, but that letter was submitted to NASBA. We'll talk more in the meeting today about licensure and pathways and so forth. And finally, I would just remind the board members that please turn on your microphones when you're speaking. It's so helpful, especially to the secretary when she reviews the minutes or the meeting in preparing the minutes, and it's helpful to be able to hear the comments. So please make sure to turn on your microphone, and if I don't turn mine on, somebody remind me, please. At this point, I would like to entertain a motion that we adopt the Roberts Rules of Order for this business meeting.
So moved.
So moved. Thank you, Kevin. Do we have a second?
Second.
Second. Thank you, gentlemen. I think we do not need a roll call vote, correct, Karen? So.
I don't believe it's necessary since you're all in the room. We
Okay.
can do one if you would like.
So those in favor, say aye.
Mr. Gilbert?
Yes, sir.
I believe it's not just for this business meeting, but for the year.
Yes, sir.
I hope I'm correct in saying that.
Yeah, and that's what the note said, and I wasn't sure on that. I should have asked you before. But yes, so we are adopting the Roberts Rules of Order for the this year?
Yes, sir, and I'm
Fiscal
sorry to
year.
interrupt you. Yes,
No,
sir.
that's fine. Thank you. Thanks for clarification. So you still good with that motion?
Yes, sir.
Ken? Okay. So we have a motion second. Those in favor, aye.
Aye.
Those opposed, nay. Okay, thank you. We also need to review and adopt the agenda. However, I would ask you to consider that we move the reinstatement application for Mr. Brown. I would like to move that in front of the rulemaking hearing, if that's acceptable. Mr. Brown is here, and there's no need for him to have to sit through a long meeting, if that's acceptable to the board. So I would entertain a motion to approve the agenda with that modification. So moved.
Second.
Second. Those in favor, aye.
Aye.
Those opposed, nay. Thank you very much. At this point, we will vote on approving the minutes for the October meeting. Pam, I don't know if you have any comments on the minutes?
I did receive the minutes and reviewed the recording as well as the written version and approved them.
Very good. Comments or questions? I would entertain a motion to approve in a second. So moved.
Second.
Second, thank you. Those in favor, aye.
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 Those opposed, nay. Thank you very much. Okay, so at this point, we will consider the reinstatement application. And Mr. Lott, I think you're going to lead us through that.
Yes, sir. I have a short introduction for the board. The respondent seeking reinstatement today is Richard Brown. While holding the position of Budget Director for Haywood County, Tennessee, respondent fraudulently transferred $17,606.22 into his public accounting business account. As a result of this conduct, respondent was charged with a criminal offense in Haywood County Circuit Court, but the charge was ultimately dismissed, and the charge was expunged from respondent's record on April 1, 2022. An administrative case was opened with this board to review the matter. And by consent order dated February 21, 2023, the following disciplinary action was imposed. First, respondent agreed to the voluntary suspension of his CPA license, number 23368, for 2 years, beginning on January 1, 2023. Second, respondent agreed to pay a civil penalty of $5,000 by or before March 1, 2023. Third, the board required respondent to complete the three-part NASBA ethics course. And fourthly, the board required that if the respondent seeks reinstatement, he must appear before the board, which he's doing today. The respondent represents to the board that he has completed all of these requirements. So that is the reinstatement request before the board today.
Thank you, Mr. Lott. Mr. Brown, would you mind to step up to the podium with the microphone? And you might want to make sure that microphone is on.
Thank you. Hello.
Okay, good. Welcome, thank you for being here, and I suspect you have some opening comments.
Thank you for having me. Yes, sir. Sorry, I'm a little nervous. I'm used to standing in front of everybody. It's just a lot of what I've had to say. Mr. Lee's already gone over it, but I was just going to say my name is Richard Brown. My license was voluntarily suspended effective January 1, 2023 for 2 years. The reason for my suspension was as budget director for Haywood County, I misappropriated funds from the county credit card. All of the funds were paid back immediately. I paid a large fine. I completed 60 hours of community service and attended an outpatient alcohol rehabilitation program for 2 months. I was indicted in Haywood County, but all the charges were dropped based on my compliance of all the demands by the district attorney of Haywood County. This has been a very difficult 3+ years for me and my family. I made the biggest mistake of my life, and it has cost me dearly. My reputation was ruined. My livelihood was lost. I was on the front page of the newspaper and the radio. Through much thought and prayer, I've tried to pick up the pieces and keep my life together. Ultimately, I learned a valuable lesson, have been humbled, and would appreciate the opportunity for my license to be reinstated so that I can try to continue to rebuild and repair my reputation, my earning potential for my family, and to continue my profession in a way that I can be proud of.
Thank you, Mr. Brown. Questions, comments from the board? I will start, and you're welcome to chime in at any time. Mr. Brown, does the money that you took or transferred, did that happen at one time, or was that a series of transactions?
It was a series of transactions over the course of about 6 months.
So
Yes.
tell us about that. I mean, did you pay a few personal bills and then it generated?
Yes, sir. Yes, sir. I was actually gambling a little bit at the time, which I no longer do, obviously, and it was very. And this is not an excuse for anything. It's kind of just an explanation
Right.
of what happened. But I did not realize that when I took the position on as budget director that it was going to be as political as it was, and just the back and forth between the county council and the mayor and I felt like I was just kind of in the middle of it, and it was very stressful for me, and I was just in a bad place, and didn't really have anybody to bounce it off of, and I did the absolute worst thing that I could do, but anyway, it did happen over like a 6-month period.
So how did that political pressure contribute to your taking of the funds?
Well, it's just a variety of factors, I guess. I mean,
Okay.
it was just one of the, like I said, I'm not blaming it on anybody but myself. I mean, I just made a terrible decision, and I think just the pressure of the position, and I think that contributed a little bit to it. But like I said, it was my actions. I mean, I'm just trying to explain why, because I'm not that person. I'm not that person anymore.
So we've talked, our investigator has helped me a lot during his tenure with us, and not in your specific case, but he's told me that sometimes these events occur that someone takes $100 and then they get away with it. The next time it's $200, and so it progresses. Is that kind of what happened in your situation?
Yes, sir. And I didn't realize that it was as much as it turned out to be. I mean, but that is what happened.
And this may be in the facts, and I just don't recall, but how was this revealed? Who called you?
I was in a debt collection service before, and one of the stipulations was they said that like a credit card company could sue me because we weren't. I guess I was paying the debt collection company, and then when they would settle with the credit card company, that they would. Then they would pay the bill, and so one of the credit card companies filed a civil suit against me, and then the sheriff looked into my credit card, the transactions and everything,
Okay.
because I had access to the county credit cards.
Could you tell us some about your community service?
Yes, sir. Worked some with, well, I'm a soccer coach for the county league, and then I volunteered with the church and with the Mustard Seed, which is like a local clothing place, and I'm trying to think back. It's been 3 years. several, I helped out with the Parks and Recs Association in Haywood County and several other things.
Has any of your community service continued? Are you still doing some things in that?
Yes, sir.
Okay.
We're very involved with the church and I'm still involved with youth sports and
Do you feel a lot at your church, for example, that you have a good support group?
yes, sir, I do. It was tough at first, but I feel like that that my church family has forgiven me and we're in a much more comfortable place and got a good group.
Good. Mr. Monroe?
Thank you. Might need to turn off somebody's mic to allow. Thanks. Mr. Brown, thank you for being here. Question that I have is more forward-looking. So if the license were to be reinstated, what are you looking to do? Are you looking to go back into public practice or more private practice, or do you have a sense yet of what that would look like?
I'm working through a plan. I think I would like to go into public practice. I think with William Lee, who's just a local accountant in Brownsville. We've had discussions about doing that, but nothing's finalized. But I would.
Thank you.
Other questions? Dr. Church?
I just wanted to point out, one of the main things we look at is what's changed. So how will the future differ from the past?
Yes, ma'am.
And I heard you say you'd been through treatment for alcoholism
Yes, ma'am.
and that you'd had a gambling problem and you've overcome that. Do you see those factors as being significant changes that will
Yes,
certainly
absolutely.
be different in the future?
Yes, ma'am. Yes, absolutely. I've learned how to deal with my stress in a much more positive way and do not gamble anymore. And I don't drink like I was drinking, and I've found much more healthy and positive ways to deal with that going
Control.
forward.
Thank you.
Other questions? Okay, so Mr. Brown has appeared requesting reinstatement of his CPA license. Do I have a motion
I make a motion to
to
approve.
approve? Okay, I have a motion to approve reinstatement. Do we have a second?
Second.
Second. Maybe we should have roll call on this, Karen. Is that okay?
Yes, sir.
So,
Greg Gilbert,
aye?
John Griesbeck,
Aye.
Pam Church, Sam Bennett,
Aye.
Andy Bonner,
Aye.
Brad Buchanan, Brad Floyd,
Aye.
Kevin Monroe,
Aye.
Rob Vance,
Aye.
Very good. So the reinstatement is approved. Congratulations, Mr. Brown.
Thank you all very much.
I would caution you to be very careful and do the things that you talked about doing today, the positive things, and welcome back into the CPA profession.
I want to thank you all very much for the second chance, and it means a lot to me. So,
Very good.
Thank you.
Thank you.
thank you.
Okay, at this point in the agenda, we will move into rulemaking hearing. And the Chief Counsel for the Department of Commerce and Insurance, Laura Martin, is with us. And Laura has been with us before. And Laura, it's good to have you. Are you delegating? Okay.
Good morning. So I think it's probably been a couple of years since this board had a rulemaking hearing. So just as a quick reminder, we're gonna kick off the rulemaking hearing here in a minute, and it's a lot of reading, so I'm kind of reading from a script. There's definitely chances to discuss the rules or anything like that at the end. But yeah, so I'm reading a lot of this into the record because that's what's required by the statute. So, yeah, so we have, you should, do they have it on their iPads?
The
Okay.
notice, it's the notice is on there with the red line in it.
Okay, they're fine.
Yeah.
Would anybody prefer, you have all of this on your iPad, but if anybody would prefer a paper copy? Yeah, okay. Okay, let's get started. This rulemaking hearing is called to order. My name is Laura Martin, and I serve as Chief Counsel for the Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the board, the Tennessee Board of Accountancy. The representative for the agency is Jen Binkley, who is the Executive Director. And then we have the board members. We have Sam Bennett, Andy Bonner, Rob Buchanan, Pamela Church, Greg Gilbert, John Griesbach, Brad Floyd, Kevin Monroe, and Robert Vance are all present. Today is Tuesday, February 4th, 2025, and this rulemaking hearing is taking place pursuant to Tennessee Anna Code Section 4-5-204 in Conference Room 1A of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and is available by electronic means via Microsoft Teams, which can be located on the Commission's website at www.tn.gov/regboard/accountancy/public meeting-information.html. On this page, the link to access the rulemaking hearing via Microsoft Teams can be found in the chart located in the middle of the page on the second row with the date 2/4/2025 in the location column under the words Nashville, Tennessee, labeled Connect. The purpose of this rulemaking hearing is to solicit comments on rule amendments to the rules and regulations of the Tennessee Board of Accountancy. These rules rewrite the process of peer review. CPAs who provide attestation work must engage in peer review. The current rules reflect older practices and guidance that no longer reflect how this process takes place. The amended rules will reflect the model rules provided by the National Association of State Boards of Accountancy, with necessary edits to show how the process should currently be taking place in Tennessee. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or prescribes the procedures of practice requirements of the agency. Proposed rules are filed with the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's Office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of that time, which will be the effective date. Those members of the public wishing to speak and appearing in person should place their name on a sign-in sheet located on the podium. Is there anybody looking to speak on these rules? Those members of the public wishing to speak and appearing via Microsoft Teams should put their name in the chat box. You'll let me know if that. And Karen, let me know if there's any names in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet or typed their name in the chat box. All right, again, if there's anyone who desires to give a comment, please sign up on the sheet or put your name on the chat box. Are there any, Karen? Are there any? No. Okay. So I would, in addition, I also have copies of the red line. Would you guys like copies of the red line? You guys are good? Okay. The notice of rulemaking hearings include the entire text of the proposed rules and were published on the Tennessee Administrative Register website November 25th, 2025. Ms. Binkley, what additional notice was given to the affected individuals or groups?
We sent out an email on January 10th to individuals who have subscribed to such updates with a link to the proposed rule changes.
Has anyone written you since that time about these rules?
No.
Okay. So I'm going to summarize the substance of the rules very briefly. So we have Rule 0020-06-.01, which adds new definitions for administering entities, peer review oversight committee, sponsoring organization, and allows the board to oversee the peer review program. Rule 020-06-.03 discusses the peer review oversight committee. Rule 0020-06-.04 discusses the basic requirements for enrolling in peer review. Rule 0020-06-.05 discusses sponsoring organizations. Rule 0020-06-.06 is repealed entirely, and Rule 0020-06-.07 discusses peer review submissions. As the agency hears public comments on the proposed rules, as the monitor, I will reserve the right to limit such comments if they become repetitive, but it doesn't seem like there are any comments. Okay. I'm going to give it just a minute for anyone to sign up. Okay. We're good. I observe no comments. Okay, so moving on, there are several measures that we need to adopt by motion and roll call vote as required by TCA 4-5-222. So, first we're going to talk about the regulatory flexibility addendum. That is something that you should have on your iPads, and I can give all of you a chance to read over it. If you would like for me to read it into the record, I can. But otherwise, I'm going to just provide a summary. So pursuant to TCA, Section 4-5-401 through 4.5-404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small businesses. Of the about 1,700 licensed accountancy firms that have renewed in 2024, 579 claim to do attestation services. This rule will not require any additional record keeping. Small businesses will not be negatively affected by these rules since they are already required to enroll in peer review if they provide attestation work. These rules are the least restrictive means to achieve the purpose and objectives. Less restrictive rules would not provide sufficient oversight of the peer review process. These model rules will be very similar with the surrounding states and any other member states of NASPA. There is no ability to exempt a small business. The statute requires that any CPA offering attestation work must enroll in peer review, and an exemption would not be in compliance with TCA 62-1-201. Do I hear a motion to adopt the regulatory flexibility addendum?
So moved.
Do I hear a second?
Second.
Can we take a roll call vote?
Greg Gilbert,
Aye.
John Griesbeck, Pam Church,
Aye.
Sam Bennett,
Aye.
Andy Bonner,
Aye.
Brad Buchanan, Brad Floyd,
Aye.
Kevin Monroe,
Aye.
Rob Vance.
Aye.
It passes. So now I need a motion and a roll call vote to adopt the impact on local government. So this should also be in front of you. This is the document that we give to the Joint Government Operations Committee. All agencies upon filing a rule must submit the following pursuant to TCA 4-5-226, Roman numeral I-1. Please review and let me know if you have any questions or concerns. If not, I will need a motion to adopt this information by roll call vote as well. Any questions? Go ahead.
I move that we adopt.
Do I hear a second?
Second.
Can I have a roll call vote, please?
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Pam Church, Sam Bennett,
Aye.
Andy Bonner,
Aye.
Brad Buchanan,
Aye.
Brad Floyd,
Aye.
Kevin Monroe,
Aye.
Rob Vance.
Aye.
So now I'm going to read into the record some of the answers for these. A brief summary of the rule and description of all relevant changes and previous regulations effectuated by the rule. These rules rewrite the process of peer review. CPAs who provide attestation work must engage in peer review. The current rules reflect older practices and guidance and no longer reflect how this process takes place. The amended rules will reflect the model rules provided by National Association of State Boards of Accountancy. There are no known federal or state laws or regulations mandating promulgation. These rule amendments impact current and future licensed CPAs who intend to or who currently provide attestation work. There are no attorney general opinions or judicial rulings that directly relate to these rules. There is no foreseeable probable increase or decrease in which state or local government revenues and expenditures would result from the promulgation of these rules. And I guess that's it. So this concludes the rulemaking hearing. Is there one last check for the chat box?
No one has entered a question or comment.
Okay. So I'm gonna ask you all to adopt the rules as amended that are on your iPads. That'll be your last roll call vote for this hearing, and then after that, it will be submitted to the governor's office for final review, submitted to the attorney general's office for review and approval. Once the attorney general's office has obtained these rules, they'll review it for legality, then sign it, give it back to us. Then I file it with the Secretary of State. These generally become effective about 90 days from the date of filing with the Secretary of State, so long as they receive a positive recommendation from the Joint Government Operations Committee. So do I hear a motion to adopt the rules as they are before you?
So moved.
Do I hear a second?
Second.
Roll call vote, please.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Pam Church,
Aye.
Sam Bennett,
Aye.
Andy Bonner,
Aye.
Brad Buchanan, Brad Floyd,
Aye.
Kevin Monroe,
Aye.
Rob Vance.
Aye.
It passes. Before we conclude, are there any comments or questions from the board? Okay, that concludes our rulemaking hearing. Thank you so much, guys.
Laura, thank you for being with us. Laura, it's always good to see you. And
Thank you.
you are, of course, welcome anytime. At this point, we will move to the section of the agenda regarding the summary suspension informal conference. And Kyle, I think you have some good news for us, actually.
Yes, good morning, everybody. A little change since yesterday. The informal hearing will not happen. The respondent in this case has actually waived his right to the informal hearing and has signed an agreed order, which should be in front of you today. I still will explain the law behind this and the statute because, as I understand it, it's been a while since the board has done this, and I think a refresher would be good. But this matter concerns Jason Jerkins. He's a licensee of the board, license number 24208, and we had set this summary suspension informal conference and sent notice to him. I will explain the power of the board now. So the board has a power pursuant to Tennessee Code annotated 4-5-320 to essentially temporarily suspend a license pending further action down the road of the board when it finds that the public safety and welfare require that emergency action. I'm going to read verbatim from the statute, just some snippets, so the board can be aware of that. The statute states if the agency finds that public health, safety, or welfare imperatively require emergency action and incorporates a finding to that effect in its order, summary action, including suspension of a license or other licensure restriction, or action as may be appropriate to protect the public, may be ordered pending proceedings for revocation or other actions. These proceedings shall be promptly instituted and determined. The agency or the board has two procedures when issuing an order of summary suspension, one of which states the agency shall issue a notice to the licensee providing an opportunity for a prompt informal hearing, review, or conference before the agency prior to the issuance of an order of summary action. The notice provided to the licensee may be provided by any reasonable means and shall inform the licensee of the reasons for the intended action and of the opportunity for an informal hearing, review, or conference before the agency. As stated, I did send out that notice to Mr. Jason Jerkins' attorney, Luke Evans. And as of last night, we also sent an agreed order out with that to give them an opportunity to waive the informal conference and agree to the summary suspension. And I received that signed order, signed by Jason Jerkins yesterday evening. Again, you all should have a copy of that. So we can go through it together, and I'll read it into the record. So again, in the matter of Jason Alexander Jerkins, this is case number ACC-2024046751, agreed order of summary suspension. This matter was presented to the Tennessee State Board of Accountancy, hereinafter referred to as the board, pursuant to the provisions of Tennessee Code Annotated Section 4-5-320C and 4-5-320D1A, which state in pertinent part as follows. If the agency finds that public health, safety, or welfare imperatively requires emergency action and incorporates a finding to that effect in its order, summary suspension of a license may be ordered pending proceedings for revocation or other action. Notwithstanding subsection C, in issuing an order of summary suspension of a license, the agency shall use one of the following procedures. The agency shall issue a notice to the licensee providing an opportunity for a prompt informal hearing, review, or conference before the agency prior to the issuance of an order of summary suspension. Whereas, based on the agreement of the parties as evidenced by the signatures below, the board makes the following findings of fact and conclusions of law. Jason Alexander Jerkins is licensed by the board as a certified public accountant, license number 24208. On or about August 21st, 2024, the board received a complaint from Micah Seeley alleging that respondent was mishandling his business and personal tax returns and had stolen monies from the complainant. During investigation, respondent, through its attorney, responded to the complaint, declining to respond to any specific allegations because the matter was subject of a current criminal investigation. Subsequently, the board received records and documentation through its investigator showing that on or about January 8th, 2025, respondent was indicted and charged in the U.S. State District Court for the Middle District of Tennessee with one count of wire fraud in violation of 18 U.S.C. Section 1343, one count of money laundering in violation of 18 U.S.C. Section 1957, and 5 counts of aiding and assisting the preparation of false tax returns in violation of 26 U.S.C. Section 72062. Respondent was indicted on the above stated charges on January 8th, 2025, and the charges are currently pending. The board may discipline a licensee for violating any statute or rule under Tennessee Code Annotated Section 621-1 ET Sec, including any fraudulent conduct while holding a license or conviction of a felony under Tennessee Code Annotated 62-1-111, and for emergency action pursuant to Tennessee Code Annotated 4-5-320. Due to respondent's pending criminal charges, he agrees to the voluntary suspension of his certified public accountant license number 24208, pending the outcome of his criminal proceedings or for subsequent license revocation proceedings or other action by the board. The respondent agrees to his voluntary suspension of his license without making any admission as to any facts or circumstances surrounding the alleged incident that led to his criminal charges. Respondent, without making any admission of fact relating to the nature of his criminal charges, agrees to this voluntary summary suspension of his license to the jurisdiction and authority of the board and to provide appropriate updates to the board regarding the status of his criminal charges upon the request of the board and upon the final disposition of his criminal charges. Respondent waives the right to an informal hearing, review, and/or conference before the board and consents to the entry of this order. It is expressly understood that this order is subject to the acceptance of the board and has no force and effect until such acceptance is evidenced by the entry of the board. Therefore, due to the agreement of the parties and waiver of the right to an informal hearing, conference, and/or review before the board finds that the health, safety, and welfare of the public immediately requires this emergency action and the immediate summary suspension of respondent's license. It is therefore ordered that the license number 24208 for Jason Alexander Jerkins shall be summarily suspended by agreement of the parties and pursuant to the entry of this order, pending the outcome of respondent's criminal case and/or proceedings for revocation or other action by the board. As you can see there, Mr. Jerkins has signed the order. So I think after reading that all before the board, if we could just get a motion for approval and entry. And if that motion is approved, Mr. Chairman, if you could sign that order.
Questions, comments? I would offer, and this is not at all something that needs to be amended, Mr. Johnson, but I know in my conversations with Jen earlier, item 5, respondent was indicted on the above stated charges, and that indictment was by grand jury.
Yes, I think that's
Yep.
good to state in the record, Mr. Chairman.
Okay, I would entertain a motion for approval.
So moved.
So moved?
Second.
Second. Maybe we should do a roll call on this one too, Karen.
Yes, sir. Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Pam Church,
Aye.
Sam Bennett,
Aye.
Andy Bonner,
Aye.
Brad Buchanan, Brad Floyd,
Aye.
Kevin Monroe,
Aye.
Rob Vance,
Aye.
Very good. The motion passes. Mr. Johnson, sorry. Mr. Johnson, I have signed this. I don't know if you need to get it back immediately or not, but anyway, it's executed. If
While Kyle comes up and gets the order, so Kyle Johnson has been an attorney with our department for probably about 1.5 years now, 2 years maybe. And while Lee is going to continue to be your program attorney and do a bulk of your litigation, you probably will be seeing Kyle around a little bit more because he's going to do some supplemental litigation work for the board. And it just so happened that his first board meeting with you, he got a summary suspension case, which, like he said, is quite uncommon for this board, and they do usually come with, you know, a grand jury indictment or a police report or something like that. So as his first introduction, he did a summary suspension for you all. So you can expect him to be here probably most meetings with some cases on the legal report going forward. So thank you.
Thank you, Laura. Thank you, Mr. Johnson. Excellent work. And I know you've spent a lot of time before today preparing for this. And Jen, thank you for your work on it. And Laura, I'm sure that you and Lee were involved to an extent. So thank the entire team for the work that you've done on this. At this point, I think we need to move to the Executive Director's Report. So Jen, your first official Executive Director's Report to the Board of Accountancy.
So yes, I'm happy to be here and give this report. You'll see in your meeting materials, I included a copy of my report. At the top is a list of future meeting dates. I did include a proposed date that we can action at the end of my report, Tuesday, February 3rd, 2026. I will note, I know y'all have heard this recently, but our ability to book this conference room that far in advance is somewhat limited. I do want to go ahead and approve a date, and we will work behind the scenes on getting a conference room for that space in the future. Upcoming NASBA meetings, there is an executive directors and board staff and legal counsel conference happening in Clearwater Beach, March 25th through the 27th. Lee and I plan to attend. We have regional meetings coming up this summer. The Western Regional Meeting will be June 17th through the 19th in New Orleans. The Eastern Regional Meeting will be June 24th through the 26th in Philadelphia. We do have 5 board members budgeted to attend, so if you are interested, please let me know. I am planning to attend the Eastern Regional meeting for reference. The 118th annual meeting of NASBA is happening in October in Chicago, and again, we have with the within the FY26 budget that is up for vote today, we do have 5 board members budgeted to attend that as well. I did not attend the 117th annual meeting of the NASBA meeting, as I had not yet started, but Lee kindly wrote a summary for me here, so I will share that with the board. Representatives from boards of accountancy throughout the United States came together for this annual meeting held on October 27th through the 30th, 2024. Tennessee's delegation consisted of board members Andy Bonner, Brad Floyd, Greg Gilbert, John Griesbeck, and Kevin Monroe, along with board counsel Lee Lott. Mr. Bonner, who serves as NASBA's treasurer, gave a presentation on NASBA's Administrative and Finance Committee report. Other presentation topics included private equity ownership in public accounting firms and a proposed competency-based experience pathway to licensure. There were updates from NASBA and AICPA leadership, including NASBA's new president and CEO, Daniel J. Dustin. The conference was a valuable opportunity to communicate with accountancy leaders from around the country on significant topics and trends in the industry. Next on the report, you'll see a repeat of what Greg has already shared, the NASBA and AICPA comment letter response on their competency-based experience pathway to licensure. As noted during the October 2024 board meeting, the Tennessee Board of Accountancy has not reached a consensus on NASBA and the AICPA's proposed competency-based experience pathway to licensure, which was documented in the exposure draft dated September 12th, 2024, issued by the AICPA and NASBA. The board indicated at that time a desire to offer written comments and questions made during the board meeting to NASBA and the AICPA in response to their request for comments on their open exposure draft. I compiled comments and questions made during the meeting and drafted a comment letter response, which was shared with NASBA and the AICPA. A copy of the response letter has been included in your meeting materials. A couple of updates on the CPA exam. NASBA notified our board staff on January 6th, 2025, that effective January 1st, 2025, Prometric made changes to their rescheduling and cancellation fees. Per NASBA, the most notable change is that they now will charge a fee for rescheduling an exam appointment 31 to 60 days before a candidate's scheduled exam appointment. Previously, there was not a reschedule or cancellation fee if an exam appointment was rescheduled more than 29 days in advance. NASBA, along with the AICPA, has expanded the international administration of the Uniform CPA exam. Effective January 13th, 2025, Bermuda was added as an international administration testing country. Candidates now have the option to select Bermuda as an international country for exam administration. Next, I'll share an update on our state-specific ethics course. So per the Memorandum of Understanding between the TSCPA and our State Board of Accountancy, TSCPA is required to give 60 days notice to the State Board prior to a change in the licensee's cost for the TSCPA online ethics course. Effective April 1st, 2025, TSCPA will increase the licensee cost from $45 to $50. TSCPA gave notice of this change on November 25th, 2024. Next is also a repeat of what you've already heard about our self-sufficiency hearing. So representatives from the Department of Commerce and Insurance and the Board of Accountancy, including Reed Witcher, our Assistant Commissioner for the Division of Regulatory Boards, Candace Dawkins, our Legislative Director, myself, and Greg Gilbert, our Chair, attended a self-sufficiency hearing before the Joint Government Operations Committee on January 27th, 2025. By statute, any regulatory board that operates at a deficit for 2 consecutive years is required to be reviewed by a joint evaluation committee during the legislative session following the 2nd consecutive year of deficit. Since our board had deficits for FY23 and FY24, we were required to attend a hearing this year. We addressed questions from committee members, and no action was taken by the committee as a result of the proceedings. I've also noted outreach efforts. So the following outreach efforts have occurred since the October meeting. We had members of the board attend the TSCPA Interim Council meeting on November 7th. I attended also in an unofficial capacity, as I was not yet onboarded with the state. And then on December 12th, Duke presented at a Lipscomb CPE event. And we were also invited by the TSCPA to speak at the TSCPA Future Leadership Summit in January, but that event was postponed due to snow. I have also, this is not in my report, but I think it is helpful to know with outreach. I have begun reaching out to universities to understand whether I can be a resource to them in their student engagement efforts. So if there are specific things that the board would like me to focus on in terms of outreach, I'm happy to take that feedback. Finally, you'll see in your materials, we have some renewal data here. So all firm permit holders and even numbered licensees received a renewal postcard via U.S. mail in early November. Renewal notices and reminders were also sent via email on 12/11 and 1/16 for licenses and 1/22 for firm permits. We also have plans to send out one more postcard renewal reminder to any licensees or firm permit holders who have not renewed in the next week or so. So we anticipate those going out as well. We've also included performance metrics from Q4. So these are metrics that our board staff is held to in terms of being a customer-focused government. So you'll see that our average number of days to license, our goal is 7 days. And for the months of October, November, and December, we were under that goal. Our case and complaint performance goal, which is the length of time that it takes from the date that a complaint comes in to the date that it is closed by the board. Our goal is 180 days. And you'll see that in October, November, and December, we were above 90% in meeting that goal for all 3 months. And then our online adoption rate, which is the rate at which our licensees are engaging with us online, doing online applications. Our goal is 80% across the division, and we were at 100% for all 3 months in Q4. The remaining information included in this packet is just some licensee information, some numbers and statistics there. I'm happy to take any questions at this time.
Questions?
I have one comment. Go ahead. Jen, I don't know that this matters, but the future meeting dates, Tuesday is October 21st.
Oh, thank
According to
you.
my calendar, I don't know that it matters per se, but
We hope that, I think that will matter for us all to arrive on the same day. Thank you.
thank you.
I would offer comment. As we discussed yesterday, we had the self-sufficiency hearing, and I'm very appreciative of Jen's participation in that. Jen was asked a question or two, and she responded very professionally. Excellent work, Jen. And then Assistant Commissioner Reed Witcher has joined us. And Reed, just excellent work on your part in presenting before the Joint Ops Committee. And so thank you for representing us extremely well. Okay, I think we have one action item. Is that correct, Jen, under your report? And that's the approval of the February 2026 meeting,
Correct.
correct? So I would entertain a motion to approve that date.
So moved.
So moved. Second?
Second.
Second. Those in favor, aye. Aye. Those opposed, nay. Thank you. Thank you very much, Jen.
Thank you.
Okay, so we will move into our board committee reports, and up first is Dr. Pam Church, Chair of our Licensing Committee.
We have 5 items. Two are requests for credit extensions on parts of the CPA exam. The other 3 are various topics. So the first one I will cover is the consideration of Belmont University's ETP 6510 Entrepreneurial Mindset class for approval as a business course, not an accounting course, but a business course. What happened with this was that it has been used as an elective in their Masters of Accountancy program for years, but NASBA turned down this course for business credit with a student who had applied to sit for the CPA exam. A professor from Belmont explained that they have used it in this way and nothing had changed there. But we're assuming that the reason it was turned down was because it does not fit a specific category of topics that are pre-approved for approval by our board as business. But there is a final category that says other topics as approved by the board. So yesterday, the licensing committee had a motion and approval to approve this for business credit under that particular category. Do I need to go ahead and vote each one, you think?
I think you all have done it both ways in the past.
I think I'll
either
go ahead and do it
individually-
because they're very different. So I bring that motion to you, and it doesn't need a second. All in favor, please say aye.
Aye.
Opposed? The second item is the CISSP exam, which has been brought to us for approval for CPE credit. This is the Certified Information Systems Security Professional exam. And a CPA had requested to use this for CPE credit, but unfortunately, after having completed it, and that is not allowed according to the rules, but Jen brought it to us to see if we wanted to add it to our fairly extensive list of exams that we do grant pre-approval for CPE credit. And licensing committee had a motion approved to bring this forward for approval and to classify it as management services with the reasoning that the Certified Information Security Manager exam is very similar and has that category. Any discussion? All in favor of that motion? Please say aye.
Aye.
Opposed? All right, the third item, people may not be as familiar with. Hold on. And this is a service that evaluates basically foreign transcripts. So this is a service that we're being asked to approve on a list that Tennessee can use to evaluate foreign credentials for candidates sitting in Tennessee for the CPA exam. The staff did a thorough investigation of this, talked to NASBA, found out that this company, ERES, Educational Records Evaluation Service, they have no records of complaints about them. They have been used, the board staff determined that they have been used by several states surrounding Tennessee, and again, with no problems. So, in our opinion, this appears to be an appropriate company for this purpose, and we did approve that motion as well. Any discussion for that? All right, all in favor of this approval, please say aye. Aye. Opposed? All right, the last two are requests for credit extensions. As you know, we've had various rules over the past few years, automatic extensions from COVID and changes with the new exam format, et cetera. But what we look for when we are evaluating individual requests are extenuating circumstances. What makes this different? And the licensing committee did determine that these did fall under that category. So the first one is Vikas Jodhav. This person has a BEC score that expires 6/30/25 and is requesting a 15-month extension to 9/30/26 due to medical issues. He developed a very serious medical condition and has stated that this has been a factor in trying to pass the other parts of the exam. So by granting this extension, it would give him an opportunity to move forward with his exam. The staff has the documentation on the medical condition, and I have heard about that, and it does fall into the categories that we have determined in the past are extenuating circumstances. So we did vote to move for approval of this request. Is there any discussion? All in favor of this extension, please say aye. Aye. Opposed? And finally, one other, Daniel Swift, who has his FAR score expired 3/31/2019. He was diagnosed with a very serious life-threatening medical condition in 2018. He has asked for an extension to 6/30/25 for FAR due to medical and COVID-related issues. He actually already has credit for the other 3 parts, just passed BEC this past December. So if we grant this, he will have passed the CPA exam. The licensing committee did vote to bring this motion for approval. Is there discussion? All in favor, please say aye.
Aye.
All opposed? All right, so approved. That concludes our report.
Thank you, Dr. Charge. And as I've mentioned previously, thank you for the double duty you perform for the board. Pam serves as our secretary, which takes a good bit of time, and also as chair of the licensing committee. So thank you very much, Pam,
Glad to
for
do it.
all your work. At this time, I would ask Chairman John Griesbach, Chairman of the Law and Rules Committee, to submit a report.
Thank you, Mr. Chairman. The board's current discipline matrix was approved by the board in October 2023, the last such approval. Our rules provide for civil penalties of $0 to $1,000 per violation, as well as disciplinary actions that may be imposed by the board on a licensee. As noted on that document, penalties are per violation, but by law, each day of continued violation may constitute a separate violation. At yesterday's committee meeting, after considerable discussion, we made several requests of Mr. Lott and Ms. Binkley related to, in particular, peer review violations that are violations by any licensee that comes before the board. We requested Mr. Lott explore the subject of peer review violations and the basis upon which civil penalties can be imposed, as well as how they may be computed. We also requested Mr. Lott and Ms. Binkley review the board's discipline matrix for any changes deemed necessary. One item that we discussed and was noted was the entry of $1,000 per year for peer review violations, something that we may want to consider a revision. Finally, we requested Mr. Lott and Ms. Binkley provide input on how this board may appropriately impose investigative, formal hearing, and administrative cost, if applicable, independently of any civil penalties on a licensee. And so that was pretty much the gist of our conclusions or recommendations from our committee as relates to this, and I would open for any discussion. Not hearing any. I'm not sure if we need any kind of a motion or if that's just a request
Don't
coming
think
out
so.
of the,
That's right.
come out of the committee.
Yep.
Great.
Thank you, Mr. Griesbach.
Thank you.
At this time, if everyone's agreeable, let's take a 15-minute break, and we will reconvene and dive into the Enforcement Committee next. Thank you. Okay. Thanks, everyone, for being back, and we will resume our meeting, and I will turn the meeting over to our Enforcement Committee Chair, Kevin Monroe.
Thanks, Chairman Gilbert. For the Enforcement Committee, we have two items. One is an information item only. It is just the case and complaint report that summarizes the active cases, excluding those that we are about to deal with in the disciplinary section of our meeting in just a moment. Generally, the cases are aged, and generally, those that are longer in tooth are simply because they're placed in litigation monitoring, and we have to await the outcome of either civil or criminal or regulatory proceedings by other jurisdictions. And so that's really beyond our control, but no real action items there. With respect to the cases that we'll be working through, just for the benefit of those that are present or tuning in, here in our committee work yesterday, the members of the Enforcement Committee went through each of the cases, case by case, had an opportunity to review the materials and ask questions of counsel and bounce ideas off of one another, and then made recommendations with respect to discipline for those cases for the board's consideration. Typically, we had three buckets, if you will, or classifications of cases: those that are on the consent agenda, that do not call for any recommended discipline. Typically, it's closure. The second batch is cases for which proposed discipline is recommended. And the third batch are cases for which a representation is made based on new facts. So, for example, something that was placed in litigation monitoring has now resolved, and we are now in a position to take action or to close. And so with that in mind, what we traditionally do is deal with each batch separately and as a batch. The items on the consent agenda are cases 1 through 6. In each of these cases, the recommendation is closure with no recommended discipline. The categories of cases address due care, unlicensed activity, and fee disputes, and potential allegations of fraud. And typically, either the evidence did not establish enough to allow for a violation, or there's a lack of jurisdiction. So, for example, this board does not adjudicate fee disputes between parties. And so in this case, the committee recommended to the board acceptance of closure recommendations for each of the cases in the consent agenda 1 through 6, and would offer that for the board's approval. I think since this is coming from a committee, there's not a need for a second, but is there any discussion or question? If not, call the roll. And Mr. Chairman, would you prefer to do this via roll call or via voice?
Either is fine if you have a preference.
I have no preference. I think we can do this via just a
Voice?
voice vote.
Okay.
All those in favor of the committee's recommendation on the consent agenda items, cases 1 through 6, signify by saying aye.
Aye.
Aye. Those opposed, say no. The motion passes. The second batch of cases are those for which proposed discipline is recommended, and this includes cases 7 through 13. We will remove case number 9, which was the subject of the summary suspension informal conference listed earlier, and unless you believe that there's a need to deal with this and place it in litigation monitoring.
I think that would be appropriate. That would be
okay.
my recommendation now, after the summary suspension, to place it in litigation monitoring.
Okay. Why don't we go ahead and pull that case 9 out, since we did not discuss that as a committee per se, and deal with that one separately as a board. And so I would posit the motion to place case number 9 in litigation monitoring. Is there any, I guess, since that was not a committee recommendation, I think it probably does need a second, and then we can have discussion.
I will second.
We have a motion and a second. Any further comment from council on that?
No, sir. Thank you.
Okay. Any discussion or questions on the part of the board? If not, we'll go ahead and call for a vote. All those in favor of the motion signify by saying aye. Aye. Any opposed, say nay. That motion passes. So we'll now deal with cases 7 and 8 and 10 through 13. With respect to cases 10 through 13, all 4 of which were stemming from contractors board referrals for folks that are issuing attest reports, either without a permit or peer review or both. In this case, in each of these cases, it was both. One of the comments in committee discussion was to delineate individually the violations in the recommended discipline policy. And I believe council has distributed new versions of the legal report that include those items and break out the violations separately to make it more clear. The overall aggregate civil penalties recommended remain the same, but in cases where there were multiple violations where, for example, it said 2,000 civil penalty, we've changed that to 1,000 per violation and delineated that to make it clear. This is case items 10 through 13. Other than that, there were no changes that the committee sought or recommended to the board. So just to summarize the cases, 7 was a CPE deficiency case for which we're recommending standard discipline. Case 8 was unlicensed use of accounting designation for which we're recommending standard discipline. Case 9 has been placed in litigation monitoring, and cases 10 through 13 are standard discipline for cases where we have attest services without a firm permit or a peer review. With that, I would offer up the committee's recommendation to accept, for the board to accept the recommendations as listed for those cases. There's no need for a second since this is a committee recommendation, but is there any comment or question or discussion on any of these cases? If not, all those in favor of that motion signify by saying aye. Aye. Any opposed, say nay. Hearing none, that motion passes. The last batch of cases are representations of cases that have been brought before this board before. And typically when we have a representation, it's because a fact has changed. It's either come out of litigation monitoring or we have new information for the board's consideration. This encompasses cases 14 through 17. Of those cases, 14 through 16 are related cases relating to a referral from the Public Company Accounting Oversight Board, where they have been in contact with our board, general counsel, and staff with respect to notice of discipline that they have meted out on a firm and on individual practitioners in association with a case. In the case of the firm, it was a significant, I believe, 7-figure fine. There were also fines of $25,000 and $35,000 levied against individual participants that are the subject of these cases. In our discussion yesterday, we had a good, robust discussion around what the PCOB can and does share with us and to what degree they cooperate, and also the fact that typically, as in this case, the PCOB has levied a punishment that would be far in excess of what we would typically levy and may even be statutorily able to levy. And so we had a discussion about piling on or not, or to pile on or not to pile on. And the conclusion of the committee was to close those cases in the sense that we did not want to pile on or did not believe that that was appropriate. And in order to retry that, the PCOB is unable really to forward us what they would deem to be confidential information that we would basically use if we were going to set up an original case against those individuals or that firm. On the last case, that's a case where additional criminal legal actions are being taken and are in process. And so the recommendation there was to move that case to litigation monitoring pending the furtherance of those proceedings. And so with that in mind, the committee's recommendation was to close the cases 14 through 16 associated with the PCOB referral and to place in litigation monitoring case number 17. Are there any questions or comments? If not, we'll go ahead and take a vote on to accept the committee's recommendations. All those in favor say aye. Aye. All those opposed say nay. Hearing no opposition, that motion passes, and that concludes the Enforcement Committee report, Mr. Chairman.
Thank you, Mr. Chairman. Your ability to succinctly summarize some very complicated cases continues to amaze me, and so thanks for the excellent work that you do.
Well, you're welcome, but I look over to see sometimes whether general counsel's office is cringing based on my summaries. So if I'm cutting it too close, just let me know. Pipe up.
Thank you very much. At this time, we will move to the Executive Committee report. And again, I would mention that several of us attended the self-sufficiency hearing. You've heard about that yesterday, and you heard it in Jen's report, and I mentioned it briefly earlier, but it was, excluding myself, you were well represented by Assistant Commissioner Reed Witcher and by Jen. And I think the committee was also pleased that at least you had a board member present to represent you. So and I know a couple of the boards were admonished for not having any representatives, Reed, so not our board, so good. So at this time, I'll turn the Executive Committee reporting over to Jen.
Sure, thank you, Chairman. So you'll see in your materials some things that we discussed yesterday. I'll recap at a high level what has already been discussed with the committee. You'll see a travel report that details Duke's travel in Q4. There was a staff meeting that I requested Duke attend with our full accounting staff team, December 11th and 12th in Nashville, and then he also traveled to Nashville for a department town hall meeting in October. In addition, you will see FY25 results to date through the end of November. Like I mentioned yesterday, I think it's important to remind that we see the bulk of our renewal revenues hitting in December and January as those come in to our financial statements a month in arrears. So we do expect to see a more positive outcome in those months when we report in May. In addition, I'll pause there. Any questions or comments on the year-to-date fiscal results or the travel report? All right, hearing none. I will move through the FY26 proposed budget. So you will see, like we discussed in the committee meeting yesterday, you've been provided with a report that shows FY23 and FY24 actuals, along with the approved budget for FY25 and a proposed budget for FY26. Some highlights in considerations made when preparing the FY26 budget. Revenues, we have projected to hold flat year over year. Our licensing numbers are relatively consistent year over year, and we haven't seen a significant change where we would anticipate a big change in revenue. We do not project case and complaint revenue as part of this, so keep that in mind when we're looking at these numbers. State regulatory fees include fees that are charged by the state by the department, I should say, on each of our initial and renewed licenses and firm permits based on the length of time that those licenses and permits are good for. Moving down into cost, I've included a detail in the report that supports the salaries, longevity and salary cap bonus, and employee benefits figures in the budget. Those are based on our current team of a staff of 4 for our licensing work, myself, and then 1 investigator. You'll also see a detailed travel budget included in your materials in attachment B, I believe, and that includes a proposed travel plan for FY26. And then the remaining costs under regular expenditures include communications and shipping, third-party professional and admin services fees. Both of those include the printing that we do of wall certificates, the printing of renewal notices, things like that. Supplies and furniture covers necessary costs for the team during the year of just one-off supplies needed by the team. Rentals and insurance usually covers car rentals that are needed as part of our travel plans. We have amounts budgeted for awards as well as employee training, which includes NASPA conference fees, the TSCPA annual convention meeting fee for myself, and some paid CPE for our investigator, computer-related items, and then state professional services, which includes things like our portion of rent on the building, IT ticket support, shredding services, things like that. Moving further down the budget, you'll see all of our departmental costbacks, admin, legal, centralized complaints, and customer service center costbacks. I will point out, we do not budget for investigations cost backs, as our cost for our investigator, like we discussed yesterday, is included up in our salaries line item. So the proposed FY '26 budget, the bottom line, we are proposing a deficit again in FY '26 in the amount of $187,485. That concludes my report of the executive committee items.
I have a question, if I may, please.
sir.
Do you know, the large penalty we issued last year on that CPE cheating scandal, have we collected that yet? Do you know?
Yes,
It
yes.
was like, what was it, 40 or
Yes.
80,000?
I think 45,000,
45?
somewhere in that range.
Did we collect that
Yes.
last year?
We did.
Okay, all right.
Okay. Earlier, you will recall that I asked for a 15-minute break. I needed a little bit of time to talk with Assistant Commissioner Witcher, so that's why we had a bit of an extended break. And I communicated with him our desire to be in compliance and certainly to be open and candid with Reed and his staff. And I appreciate the great working relationship that we have. And so I did express my concern about our proposed budget and deficit. And Reed, I guess I'm putting you on the spot, but I don't know if you have any comments to offer. You did mention a couple things to me that I can reiterate, but that you felt positive about a couple of things that we might be doing. Department, do you care to comment on that, or? Oh,
They changed some of the microphones, and now I don't know how to use any of them. Yes, thank you. Chairman Gilbert got to sort of listen to the department's position on fee increases or fee reductions, which aligns with the Government Operations Committee's preferences. Generally, what we're looking at is that a healthy reserve balance for a board would be between 1 and 2.5 times a board's annual expenditures. So you all are in that sweet spot right now. By the way, that's not always the easiest place to land when you're setting fees for a large licensure base. But you're currently in that sweet spot. I think that with the proposed budget for FY '26, you will be spending down. It's likely that you will continue to be in that sweet spot as your budget doesn't account for disciplinary action. And so I think that for the time being, the department's philosophy on this would be that it's appropriate for you all to continue to spend some reserve dollars before a fee increase would be considered. Chairman Gilbert and I discussed the timing of fee increases. Fee increases are generally implemented on July 1st, regardless of when a rule package is finalized. And if Laura's still, Laura, hop in if I'm explaining that incorrectly. But generally, if you were to pursue a fee increase now, which again the department would not recommend, you would be looking at a fee increase to take place in July of 2026. So that would be for the beginning of fiscal year 2027.
Yeah, anytime fee increases are executed in rules, they don't go into effect until like the following, like start of a new fiscal year. Fee decreases can take place anytime. And then the only exception to that is, I think if you're in the red 3 years, 2 years, 3 years in a row, then they'll let you, then it will be considered like imminent that your fee increases go into effect. So, potentially they wouldn't have to go in right at the fiscal year, but generally that's what we aim to do.
I'll add also that I mentioned to Chairman Gilbert, as we're considering what would be appropriate, the division is taking some steps right now, and I know that this board has had discussions about this recently as well, to recoup some of the legal costs that the board undertakes when you're taking action against a licensee for a violation. It's the department's position that Rather than raise fees, the people who are bad actors in the space should be responsible for paying for the legal services to review their bad actions. And so that's one thing to consider that represents a shift in what we're pursuing when we're taking action across programs. The other thing, and not to, I know there'll be additional conversation about this today, but as we anticipate some change to who is eligible for this license in the near future, between conversations that are happening at NASBA, TSCPA, the General Assembly, at the department, the possibility that you all have new licensees who will be seeking a license is another thing to consider as we look at what your future revenue opportunities may be.
Thank you, Assistant Commissioner Witcher. Very, very helpful, very insightful comments. And as I've mentioned time and time again, we want to be cooperative with you and your team. And I did mention to Assistant Commissioner Witcher that most all of us are CPAs, of course, and we generally don't like red ink. And so it raises some red flags when accountants see red ink. And but it sounds like we may be still in that sweet spot on the reserve. So thank you so much. Do we have comments or questions regarding the budget?
I just, at the last there, you talked about changes to the accountancy code for profession, obviously what NASBA and the TSCPA and other states are talking about right now. Have we, is administration considering a change to that?
Potentially, and I think that there's a future agenda item perhaps where we would have additional discussion about that. Any recommendations that the department would make on that go through the governor's office as a position from the governor, not by the department. As we consider appropriate recommendations, it wouldn't be based on potential licensing revenue, though. So for the purposes of budget discussion, that's not a consideration as we weigh potential changes.
Other questions or comments?
Chairman Gilbert.
Yes, sir.
Read the point you made a moment ago around change in posture relative to recouping fees from bad actors. That was as you rightfully point out, was a topic of conversation yesterday, and this is more of a question for me maybe than a comment. But what is the protocol if the board wanted to change, or the accountancy board or the individuals on staff wanted to change that posture? Is that something that needs to go through the governor's office in order to implement, or is that at the discretion of individuals in this room?
Generally, no, I don't think that would need to go through. So we are seeing programs when consent orders are authorized include those costs in the terms of the consent order. So that would be a step that the board could take to implement that change. Laura, you want to add
I
to
was
that?
just going to say, one of the things that we've really started to work on is anytime a case goes to a formal hearing, we are including investigative costs, and once formal charges are filed, we ask our attorneys to start keeping track of how much time they are working on that specific case. And so we did recently have a judge approve that. So for cases that are going all the way through to a formal hearing, they take significantly more time for an attorney to work through. And then we're having discussions about investigative costs and attorney fees during the settlement phase. But right now, we have had a judge approve attorney's fees and investigative costs in an order. So that is a positive in that direction, that they're understanding our attempts to work through that.
And as I think all of you know, we have a discipline matrix, and it might be helpful for us at some point to have some system or some way to estimate the costs, because as we assess penalties, most of our cases, as you all know, do not end up in formal hearings, and how to allocate some time for investigation and some legal fees. I'm not sure that we have the guidance.
I think I probably need to have some more internal conversations to give you really good advice on that.
Good.
I know yesterday you guys had conversations about, right, so generally the statute that all of reg boards falls under gives you that like $1,000 cap, and it's per violation, per day of the violation. Most boards don't really use the per day, just because that gets very complicated, which I know that Lee and Kyle explained to you guys, but that doesn't mean that we can't start looking to increase our recommendations where we do have the appropriate documentation, where it's, where, in a case where it would be appropriate. But I do think that so long as we're staying within the confines of that statute, we can look to try to maximize those costs. The thing is, a lot of people probably choose to settle because they're aware that that means they will pay less of a fine than if they go to a hearing. So I think it's all just a little bit of a balance, but I certainly can't predict anyone's behavior, so I just think that's probably something to remember.
Thank you. Mr. Lott, did you have a comment, or?
I have nothing to add. I agree with that, and we have a marching order from the Mr. Griesbeck about reviewing the matrix, seeing what we can add there, and any recommendations we can make to the board, and we'll be reporting back next quarter.
Thank you. So the chair would entertain a motion for the adoption of a budget at this point.
So moved.
So moved. Do we have a second? Have a second? Any more discussion? Let's do a roll call, Karen, if that's okay.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Pam Church.
Aye.
Sam Bennett.
Aye.
Andy Bonner. Brad Buchanan. Brad Floyd.
Aye.
Kevin Monroe.
Aye.
Rob Vance.
Aye.
Very good. Motion passes. Thank you. And thanks again, Assistant Commissioner, which are very helpful in your comments, and we appreciate you working so closely with us. The next three agenda items could be very closely related, and but we'll try to keep them as separate as possible. But at this point, I would ask NASBA Board of Director member and NASBA Treasurer Andy Bonner to present a report.
Thank you, Mr. Chairman. We got together in January on the 24th to have a NASBA meeting. Dan Dustin, who is now the CEO and president of NASBA, had his entire staff there. And so it was quite wonderful to see the changes that they're making, the action items that we were presented. And Dan did some things a little differently in that each new senior director that he has hired actually got up and got into the pit, is what we call it, and gave presentations. And one of those was Wendy. As we all know, Wendy went over to NASBA. And it was just refreshing to see how NASBA is working together and bringing changes within. One of the changes actually came to this board over a year ago, and it dealt with, we're a CPAY state, and so they do their application processing for the Tennessee. Bill Emmer is now the new COO, and he brought together the staff, and he streamlined the CPAY's application process. And he actually said he brought his staff together, put a whiteboard in a room, and engaged the staff and empowered them to come up with a solution. Which to me was amazing in that it used to take 10 weeks to process an application. Now it's 10 days. So report back to this board that timeline has come down immensely. And so, so they heard not only from Tennessee, but other states that they're doing CPACE 4, and they've called an action plan and they solved it. Now they're focusing on candidate calls and emails. And we got the first look at a new app that will go on an iPhone or Android, and it'll be out in the fall of '25, and it was amazing. And I think that that's really going to go a long way to help with new applicants who are trying to sit for the CPA exam. And so we were very excited about that. We got an update on ALD. ALD is something that all but 3 states and jurisdictions use. It's an accounting license database. It's something that even when I was head of that committee, I couldn't even look at. That's how safeguarded it is. So you have to be an executive director or a staff of a state or a jurisdiction to have access to it. And what they're talking about doing is they're going to get a task force together. We actually have some money left over in the budget from where we're not going to have to do anything with the competency-based kind of training, experience training. We had talked about putting that out and doing an app for that. That since has been shelved right now, and more on that in a few minutes. But what we're going to do is we're going to develop a task force in NASPA. The task force has been pulled together. We've added some executive directors. I have been asked to be on that task force, and they're going to rewrite the platform and enhance it. So there's lots of executive directors out there that want more rigor involved with it. They want more information. We're worried about safeguarding that information, so they're going to tighten it all down and really put it on a different platform. And it's going to be more useful to the states and jurisdictions. And so they're really focusing on that right now. And I think that they've told me that to expect to meet several times and spend 30 to 50 hours just on that one project in the next coming year. So that's been really interesting. The other thing that we got an update on that's, well, before I leave ALD, I will say that Hawaii has never been a part of ALD, but New Mexico and Vermont have been. They had to come out with new software changes, and they're coming back in. So all but one jurisdiction will be a part of ALD. So it'll be some great information for research. I know Wendy always told me she used it. I know Jen is sitting there nodding, so she knows what it is, and she's using it. And it really is a good tool for the state boards. I will say that Prometric came to the table and said that they're going to allow bulk scheduling for CPA exams. We had some of the larger firms come to us and say, hey, it would be really good if we could get our staff, to take a test or part of the exam at the same time. So we can say, okay, everybody, this day you're in the office, let's go down, we're all taking the exam. They won't take it together, but they can take it in a group setting where they're in their own little area. And so the Prometric has opened that up so that larger firms can take advantage of that. And because some of the larger firms are saying it really would help us if we could, we could kind of coordinate when and have classes start and close so that we get people on schedule, kind of like the old days when they offered it twice a year. And
Universities are doing that too.
are they really? So that's fantastic. The ELE program, regardless of what is put out, we were told that Educate, Learn, and Earn, that 245 firms signed up for that. Obviously, with some things going on in the profession, that may change some. But right now, it seems like that we just completed a pilot run and 25 people actually completed that. And they're updating the pilot run and they're first open it up to more people. A lot more to come on it. The thing that I'm going to ask Kevin here to kind of talk about, and I'm going to set it up, is that the 120 versus 150. And we've since got away from that language. It's a degree or a master's. And so the 12150 is not mentioned anymore. So, and the reason for that is that some schools are looking at 90 hours being a degree, a bachelor's degree. And so, so they're saying bachelor's degree or master's. When we met, and this is how fast this is changing, when we met in January, 11 states had actually gotten together to put together a bill or draft a bill or had actually had passed a bill, one of those three. Now there's 17 states that are in that. Over 31 states have acknowledged that they plan on, at this point, that they plan on changing this new pathway to a bachelor's degree. And I emphasize that word, bachelor's degree. We're trying to get everybody to say the same thing. Now, how hard this is, we were told when there was 11 at the board of directors meeting that 9 bills were totally different. 9 of the 11 were totally different. And so there's no consistency. As everybody knows, there were exposure drafts that were issued by the UAA and also the task force. All the comments are scheduled to be actually released in the middle of February or by the end of February, is what we were told. They're redacting the names unless those people gave authority to, or gave permission to go ahead and put their names on the responses. So we expect those to get out. We got a lot of comments. The biggest comment was on training. Signing off on the experience was an issue. The competency-based approach was an issue. And so, but from there, it was kind of all over the place. I noticed this morning, I'm actually on peak, and this morning Sue Coffey was actually giving peak an update at 9 o'clock our time on an hour update on what's going on now with UAA and how they're going to approach it from the AICPA side. Next week, the AICPA and NASBA are coming together to talk about what they need to do to look at the UAA. And with that being said, at this point, I think I handed out a map to all the board members. I know that everybody up front from council, the executive director and Karen have one. I know that Kevin is going to talk about it since, you know, let me pause here and just say, we are so blessed as a board to have so many active members that are working with, have worked with the Tennessee Society of CPAs or on committees with NASBA. Kevin has done a fantastic job and challenging job, quite frankly, being on the UAA committee. And he is more heavily involved in this. I can tell you what I was told, but why listen to me when I got the guy sitting right across the table from me? So I gave him this map and asked him if he would kind of go through and show the problems we're having in our profession trying to keep mobility in the issues. Kevin.
Thank you, Mr. Bonner. Let me just kind of level set. So I started in the profession in what I would call the Jurassic era, where we sat for the exam, pencil and paper, twice a year. And also where if you practiced in multiple jurisdictions, you had to be individually licensed in each and every one of those jurisdictions. And at one point in my career, I had to be licensed in 9 different jurisdictions and pay annual licensing fees, et cetera, and keep up with the different jurisdictions' education requirements and so forth. Well, gradually over a 20 or 30-year period, we got to the point where virtually every jurisdiction in the country is deemed to be substantially equivalent. And what does that mean? You know, I keep my original license, which is from the great state of Iowa. I have a reciprocal license in Tennessee because that is where my domicile is now. And I don't have to be licensed in other jurisdictions. And so we have made great strides jurisdiction by jurisdiction over decades to get where we're at, where virtually every jurisdiction is substantially equivalent today. Now, we have this situation where I guess you could argue, as a pessimist, it can only go downhill from there if we screw this up. And so, as we talk about substantial equivalency and automatic mobility, which are not identical terms, what we have to be careful about, and all we can control really is our state, is getting ourselves in a situation where, in the desire to open up the profession, we actually either impose new burdens on our existing professionals in Tennessee to be able to practice in other jurisdictions, because we might not be deemed to be substantially equivalent, or even if you call it automatic mobility, our guardrails around that, for example, passing the exam, meeting whatever the educational requirements are, and having the requisite experience levels are not the same. And then it becomes, well, are they equivalent or not? So we could penalize our own professionals and harm their ability to go into other jurisdictions to practice. The other downside potentially is that we could see other professionals coming into practice in Tennessee that we have to recognize, their domicile state standards. And what if a state decides, well, you know what? You don't really need to pass the exam. We'll call you a CPA without that. Or you don't even need anything beyond a GED or a high school degree in terms of education. We'll let you practice without that. Well, everything works until it doesn't. And so as we go through these legislative packages, I think we need to be mindful that we don't want to hurt either our resident practitioners or who might be beset by competition from folks that don't have to meet the requisite requirements in other jurisdictions, or that might be penalizing our practitioners when they travel to other states because we don't meet other states' jurisdictions. So right now, we're in a happy place with substantial equivalency. But as jurisdictions split off, and as Andy talked about, there are plenty of avenues to do that, we risk not being in a place where it's easy to determine whether an incoming CPA from another state is qualified to practice, or whether our residents are qualified to practice in other states. And so there's kind of an ideological divide here. Substantial equivalency where we exist today basically makes those issues easy if you're deemed to be substantially equivalent. Now, I think there's been some discussion that the AICPA portion of the UAA committee membership favors, determining this on an individual by individual basis. And that's nice, and it's easy to say we have automatic mobility and I've got my license and I can go anywhere I want anytime. And it's kind of free of regulatory oversight or burden. But if you are a state regulator and charged with protecting the public, that's a very different mindset than being able to easily determine consistently whether or not someone meets the criteria that we have set in our state or not. And so as we fashion legislative packages, we just have to be careful about that, because again, we're starting from a good platform, and as states spin off, it may be difficult to maintain that. And so we get to the UAA, or the Uniform Accountancy Act. All it is a model rule, but it provides hopefully a basis for jurisdictions to provide for some commonality, so we don't have to go back to the 1980s and deal with 50 different sets of rules for CPAs. And it does not take away the authority of any state board. They can choose to follow it or not, depending on their statute. And this map, Andy, that you distributed is a great one. In some cases, that's delineated by statute. In some cases, the board has the authority to basically determine that. That would be the case in Tennessee. But we definitely try to comply with the Uniform Accountancy Act in nearly every major way imaginable. And so stopping there and just talking about the notion of the competency-based pathway, which has been a topic for the UAA committee, it is, I think, my view is that a vast support for the competency-based aspect of that pathway has not materialized. at least as it was designed in terms of having employers sign off on fairly particular qualitative evaluations of employees as part of their experience determination. I cannot speak for the committee or NASBA or the AICPA, but I think where we're getting to is we're likely going to get to a situation where it's a master's degree and 1 year of experience, similar to what we've been signing off now in most jurisdictions for experience, or a bachelor's degree and 2 years of experience with maybe a little window dressing. But I don't think we're going to see anything like the initially proposed competency-based pathway. And that's a personal view, not an institutional view. But Andy, let me stop there and just have you chime in on any additional things I'm overlooking or missed.
I pretty much agree with you. The thing that we've noticed is that the definition of experience is totally different by jurisdiction or state. That some states are saying automatic mobility, however, this is what we expect experience to be, and oh, by the way, it'll either be in statute or it'll be, the board will actually do a rule for it. And where you start, it looks like that everything's the same, but when you start looking at what the boards are proposing, there's a big difference in the definition of experience and documentation of that experience. And that's what concerns us at NASBA. Whether you say substantial equivalency, one of the things that if you look down at your map, 11 states use in-clause to determine what substantial equivalency is. Well, number one, it relates to NASBA making that determination, but let me tell you how it works at NASBA. In-clause is nothing more than, okay, I'm not sure this is the same. They send it back to the state board, just like we got the request on the where they were approving education today in our meeting to say, does this qualify as an accounting course? They send it back to the state board and say, is this substantially equivalent? Because ultimately, it's a state board that makes that decision. And NASBA doesn't charge for that or anything else, but they want to do with that, do away with that. And 11 states would actually have to go back and it's in their regulations and change the regulations just for that. The 150-hour rule, well, several states that are in there at the 150-hour rule, there's 7 that specifically mentioned. Some of those states aren't even going to go back and change that. So how does that, if we take substantial equivalency out of it, how does that affect those? And these were the conversations, because it's like a puzzle trying to figure out, we're making so many changes so fast, how is it going to affect mobility? And that's our biggest concern. And of course, we have 9 states that surround Tennessee. And right now you got Georgia that's sitting on a 150. I think Georgia is one of the ones that's already drafted some legislation that changes that. But some of the others are not going to change it. And you have 4 states that currently have automatic mobility. And I talked to the guy that came up with automatic mobility at our board retreat, and he said that, hey, it needs to be automatic mobility because it's automatic. And then the question comes back, what if another state, and we actually had this brought to us at one meeting I was at, that said, what if one state says, okay, we're going to let a high school student come in and get 8 years of experience and then go through something like the CGMA and take quizzes and master this competency-based pyramid. And then once they get to certain levels, then they can sit for the exam. And then they become a CPA. Well, the question is, if you open it up to automatic mobility, is that person allowed to come into our state to practice? I don't know. I would assume yes, that we would have a hard time, because that person can come in our state, practice, leave the state. Then what if that person moves into the state? Now we're licensing somebody that has a different credential than what our state allows. And so there's so many questions and so many different ways this thing can go. I think that the AICPA, from what we were told, the AICPA and NASBA are getting together to talk to the UAA committee to try to get them to at least come up with a model rule. And that's the reason that Mr. Monroe did a great job of sharing the concerns and problems in that area.
Mr. Bonner, one of the concerns that I have is, I guess, centered around nomenclature. So if you look at some of the rules or the statutes the states are proposing or already have enacted, maybe, the word automatic is defined differently. And it doesn't take the common use of the word automatic, it's automatic if. And so that, to me, that complicates the statutes among the states.
I think one of the other complicators, I mean, it's one thing if you're working as a sole practitioner or a local firm that really doesn't deal with other jurisdictions, but if you're a national or an international firm or a regional firm, the HR aspects of managing that issue, you know, for thousands of employees are not easy. And so, you know, that's why I have misgivings about the fact that we're seemingly moving away from what I call the happy place, where the standards were in place across the country, and now we're going to just kind of peel them off. And it's just going to make it harder on everyone if we're not careful. But above all, whatever we do in Tennessee legislatively has to not penalize our existing resident CPAs, either in terms of their qualifications to become a CPA here or penalize them in their ability to move elsewhere. And so we kind of have to hold up our end of the deal as a state from a standard-setting process, whether we call it substantial equivalency, which I think we should, because it's a concept that's been in place for decades. It's been legally adjudicated in multiple jurisdictions. People understand what that is. Versus what you were saying, Mr. Chairman, about automatic mobility. Well, is that with guardrails or without? And with guardrails, well, which guardrails? And, you know, when you get down to it, it's a semantical argument. But I don't think, from a regulatory perspective, most of us want to allow practitioners who are unqualified to practice. But we do want to encourage new practitioners to become qualified. And that's why I believe the support is moving in favor of a bachelor's degree and a pathway to do that with 2 years or multiple years of experience. I think that's a good thing in the long run, potentially. But it's opened up this Pandora's box of where we're going to now have to deal with jurisdictions that are all over the board.
Greg, may I make comments? As a professor and dean, I'm sitting here thinking not so much about the practicing CPAs, but the potential CPAs. One comment you said was we're trying to clarify the language, so we talk bachelor's and master's, not 120, 150. That's a big statement because, number one, of course, you said undergraduates are changing, but the 150 versus a master's, you know, when the 150 hour requirement was passed, that was a big part of it was that you didn't have to get a master's. Now, I sort of like the idea of the master's, but I also know some candidates rely upon the flexibility of taking extra courses. So if they have a degree in something else, maybe they don't want to get all the prereqs to a master's and the master's, maybe that would keep them out. And in our case, we're trying to decide what to do about the master's. I know at Rhodes, they have a robust master's, but some students would finish the undergraduate, and if they had enough hours, they would pick up some, maybe even online courses, and just try to take the CPA exam as quickly as they can. And I always hated that they didn't come to the master's, and yet that fit their case. So how much discussion has there been around 150 versus master's? It sounds like you're saying, did you mean that we're going to take away the 150, or the 150 wouldn't qualify for just 1 year of experience? What is it?
And so the way I said it, 120 and 150 won't be referred to anymore. So one of the things that I believe that Mr. Monroe's committee is very close on is that there's three pathways. One of them would be a bachelor's degree, and notice 120 is not there anymore, or a master's degree, or the equivalent of a bachelor's plus 30.
Okay. So bachelor's plus 30
yeah,
replaces
would
the
be the
150.
150, what we call today.
Yeah, and just to add to that, in particular, during the deliberations or our discussions, we're aware that this is particularly for academic institutions, potentially a fairly, earthquaking type of an event, because if you built your plan around matriculating master's degree students to even be able to sit for the exam, and now bachelor students are eligible, well, you have to examine or re-examine what you're offering in the undergraduate curricula. And so the notion there was to continue to allow for that. I mean, I myself have 150 hours, but I don't have a master's degree. And when I sat, you only needed 120 hours. And so that was a consideration to make sure that there was that continuing avenue. It is counting hours per se, but there are just, a number of students that are going to fall into that patch that shouldn't be penalized.
Thank you for that clarification, both of you.
Chairman Gilbert, I have a question.
Sir.
And I appreciate both, I appreciate the comments and the perspectives. It's very helpful. But I think we're also, we're talking about this as practitioners, right, who care about the profession sort of holistically, which is appropriate. But I think as a regulatory body, our charge, right, is to make sure that we are protecting the interests of Tennesseans as well as, those who are receiving CPA services or Tennesseans who may be potentially providing CPA services outside of the state. But if the board is, again, per this map, the board, this body, determines substantial equivalency, right? We know that it would appear that the map is changing, right? States are going to do whatever states are going to do. That's obviously nothing that we can influence. How does this body, what's the process, since this seems to be a bit of a moving target, if California or Oregon or Georgia or any of the other states or territories changes their rules around what it means to be a licensee in that state or in that jurisdiction, I would imagine, therefore, this body then has to consider whether or not we would extend substantial equivalency to that jurisdiction or the licensees from that jurisdiction. Is that correct?
Yes, I mean, we in our state right now, the board basically is the ultimate determiner of substantial equivalency. Now, what we have done is we have basically modeled our determinations based on the UAA, and so there's kind of a common frame of reference. There are, I'm not sure what the governor's office is going to be proposing on this issue, and I think the Tennessee Society has a legislative package that they generally produce every year for consideration by the legislature, and so I'm not sure where those are at. But, I mean, at some point, somebody has to make the call from that regulatory public protection standpoint, and right now, it's the state board in Tennessee.
So as Andy mentioned, there are 17 boards or legislatures that are changing or potentially changing the rules. So is this for purposes of the next meeting and future meetings, is this a standing agenda item? To the extent that legislation starts to change, that this board then needs to consider whether or not that state's change would still afford their licensees substantial equivalency in Tennessee?
I think we'll have to deal with the outcome of what those other states do, but as Mr. Bonner alluded to, hopefully in the near future, when the leadership of the AICPA and NASBA have their summit meeting to try to see if there is a meeting of the minds, particularly on sections 5 concerning the licensure requirements and section 23, which deals with aspects of this and mobility, we can come out with at least a common reference to basically expose a UAA that says, okay, this is the model rule. States, you always have the authority to deviate from it, but depending on how far you go and how low you lower your standards, you may be jeopardizing your practitioner's ability to move to other states who are not going to buy off on, for example, if you choose to make the CPA exam optional, we might not buy off on admitting outside of the state practitioners to practice under that convention. What I'm worried about is that we, depending on how the legislature packages work through, I still think it's important that from a practice and public protection standpoint, in my view, the state board still needs to have that determinative authority in this particular case. I don't really want California telling me or this state what, we ought to accept in terms of our practitioners' qualifications. If they're out of bounds and they're not substantially equivalent, that's where the rubber meets the road. And I hate to pick on California, but they certainly pick on us, in some of their legislative endeavors. And so, this is really going to be an ugly sausage-making event for the next few months, and it should be on our agenda because we're going to have to pick up the pieces.
Yeah, and that was, I'm sorry, Pam, that was my question. Regardless of whether or not the UAA gets consensus or what the consensus says, certainly if there is updates or amendments to the UAA and we as a board can look at that and say, presuming that we think that makes sense and a state adopts that sort of verbatim, there really is no debate. But to the extent that a state deviates therefrom, that I would imagine would trigger this board's oversight to say whether or not the deviations cause us to have concern about substantial equivalency and then update or adjudicate accordingly.
Right, and where that matters is now I won't say it's an easy determination, but it's not a hard decision to make if the incoming CPA is from a state that's deemed to be substantially equivalent. It's like, okay, we look at that documentation and we say yes. But imagine if we lose that platform, that ability to do that easily, then it becomes a case-by-case, transcript-by-transcript, exam score validating by exam score validating process to adjudicate each reciprocal licensee who wants to move into the state. And then that taxes our staff. Sure. And so there are real-world consequences to that.
So I will say that one of the things is that California actually has over 150 people on staff for their Board of Accountancy. And they're doing all that themselves, so, I'm sitting there thinking, wow, what the cost would that be?
I think it's important to note, Brad, your question is excellent, and thank you for raising that point. I do think we could separate potential Tennessee legislation from what other states do, though, because I think your point is great. Even if Tennessee enacts no changes, I still think we have to deal with this because the other states are changing and substantial equivalency changes. So, yeah, it could be an agenda item for every meeting in the future.
Right. I think A.C. Witcher mentioned or intimated there may be something coming from the governor's office around legislative changes, which would impact our rules in Tennessee. But I agree that is a separate matter from the substantial equivalency. They obviously are interdependent or could be, but those are not the same questions.
I hope that we do consider this from the educational perspective quickly, because lots of people have been waiting as it's been debated, and students and schools are definitely affected, and of course our whole profession's affected. But as I listen to this, it seems like that's sort of a first step. The substantial equivalency has to build on that, right? And I'm not sure what's happening in the governor's office, but that may affect it too. Do you think, Andy, you listed when meetings are coming, do you think this is appropriate for us to consider next meeting?
Yeah, I would say that it's definitely appropriate to consider and to keep talking about as we start to see the states pass bills. It's something that we need to be very much on. I mentioned a comment earlier where we were talking about a high school person who had 8 years of experience except for the exam. When I was on that call, the comment was made, surely you're not implying that the 3 E's, education, exam, and experience, that you're talking about pulling one of the E's off. education and inserting something different. So everybody's very much that it's kind of all over the place now. It's like this agenda has been used to pull everything down and say, we need to look at a fresh start. And I think that you're going to see some research start to come out about what we should do because, you know, I know at one point they were looking at a 10-year plan, and now it seems like that a plan that would be 10 years away is now being brought forth to like, okay, maybe we need to look at how we do everything. And so I do think it's something we should continue to talk about. I'm very thankful that Mr. Monroe is on the UAA committee and has a seat, and you know, I think we're very well represented as a state. I know that other people sitting around the table are involved in it, including myself. Obviously, you have a big vested interest in this from your life and what you have done for the accounting profession here in Tennessee. And so I think it's something that we should talk about because, you know, 17 states have got the bills that they've either drafted or they presented or they passed. There's a total of 31, so we have 14 more states that are active in the process that said that they're going to do something, and that was a January number, and I'm sure that number has increased. So I don't have an update on that number. It's happening very fast in our profession.
Yeah, Mr. Bonner, Kara is also presenting in a few minutes, and I think she may have some updates for us. Do you mind also to touch on any action that's going on with Peak?
Well, the other thing that we learned at the board, and then I'll hit Peak, is that there is alternative practice structures are really becoming an issue, either from the private equity investments or, and let me get the Peak agenda here and I'll tell you exactly what time that's happening, from private equity investments or from ESOPs. And, you know, that some of the state structures in how we adopt a firm deal with that the members of that firm have to get CPE. Well, in some of the structures, you may have members that aren't subject to CPE, or it has to be an actual human and not a trust or something else. And so we kind of got the update on Peak today at 1 o'clock in the open meeting, Peak Online. Peak is going to send out invitation to comment. Now, this is something totally different than we do at Peak. It's not for a change, but it's just an invitation to comment. There are so many different alternative practice structures that are being developed in the right now, and there's so many different gray looks at them that Peak is going to take what we see as you know, as alternative practice structures actually go ahead and put out the matrix that they have used to define who is independent and who isn't, and do we have an issue with the test engagements. And they're going to ask for, not only for us to look at it as a stakeholder, but also to say, have we considered every alternative practice structure that's out there? Because they think that, and I agree, we as Peak agree that we need to have something out by the end of this year, period. This is happening so fast that we need to get guidance out and determine, because we're getting calls from a lot of firms saying, are we independent or are we not? And, you know, it goes so far as you have an office. The office, you walk in the door, the left side is consulting, the right side has a different sign that says a test work. The same person behind the doors may be working on both. And so they, you know, and they may have the same board of directors. But they have partners that are just test partners, but they may have other people from the consulting side that sit on the board of directors. And so that is supposed to be voted on today. And if that happens, and I'm being told that, because I sat in on the committee this last month, or the task force, I should say, and that'll be out in the middle of February. So I encourage all accounting firms in the state of Tennessee to grab that document and comment, and that's what they ask us to do. And so that was the last thing that we kind of went through at the board meeting.
Mr. Bonner, I'm interrupting you, but I think this is important to mention at this point. There's a really a national expert. His name is Matthew Bosher, Bosher, and he presented at the annual meeting of NASBA. Mr. Bosher is an attorney and a CPA, and he was former chair of the Virginia Board of Accountancy, and he's worked on over 40 of the alternative practice structures, basically representing the folks who are doing these kinds of transactions. And he, as I mentioned, presented to us at the annual NASBA meeting, but he also did a webinar for NASBA, I'm guessing 6 or 8 months ago, and I believe that was recorded. I participated in the webinar, but I would encourage each of you to do that. I suspect, Jen, that Wendy could help us get that webinar distributed, but I would encourage each of you to watch it. It's maybe a couple hours or so, but be well worth your time, I think.
I agree. It was a fantastic webinar to help you kind of understand what's taking place.
I interrupted you.
The last thing we got was an update on peer review. What I thought was really neat was that we started back at the point of how did we get here, and where are we going? And so I'm not sure that was recorded, but they actually said during it that any state board could request that wanted to know more about peer review and how it works, since we deal with it so much. And it might be something good for us to consider as a board in the future to maybe have that presentation. And that's all, Mr. Chairman.
Thank you, Mr. Bonner. Great report. I do want to mention, why do we get involved in NASBA? Is it important to us? And I think it is very important to us. To me, I learned a whole lot, so I think I'm a better board member. But a very practical thing that happened, some of you were on the board a year ago, maybe 18 months ago, and we had, I think it was a dean from the business school at Vanderbilt, Mr. Bonner, is that correct? Who asked to speak during the public comment section, and they were having, their accounting department, Vanderbilt, was having substantial issues with scheduling students sitting for the exam. And Mr. Bonner took that to the NASBA board, and you heard from the report that has been fixed, correct?
It not only was fixed for us, but it was fixed for every state.
Right.
So that uses a CPAs or a CPAS rather. So it was quite
very practical.
It was very practical and very much needed, and it was great that the dean reached out and talked to this board about it, and we were happy to say that we did something about it.
Thank you. Any other NASBA committee updates?
Greg, I'm on the Education Committee now. We just had an introductory meeting, and I was only able to attend part of that, but we'll be bringing information from there. I have been for several years on the Exam Administration Committee, so I transferred to Education.
Great. And I transferred to the Enforcement Resources Committee, and it's been very eye-opening the way our board operates compared to many of the boards across the states. I think we're more efficient. I think we use our resources better, and but I'm not the chair of that committee or the staff liaison person, so I've not really submitted all that information yet. But NASBA does offer a lot of resources, including if we had an overload, for example, in cases that we needed to investigate, they do offer resources where they will contract and do some investigatory work for us. And they also offer some legal assistance if we have cases that get involved in litigation. But we have a very capable legal staff, so that's not something that we really need. But anyway, those resources are available through NASBA.
Mr. Chairman, I continue to serve on the Communications Committee, and in October at the annual meeting, we sponsored a breakfast with which a number of participants here, members that were at the conference, attended. And since then, we've only had an organizational meeting, but another meeting coming up next month. And the focus is going to be on what state boards need from NASBA's committee, most of which are offered free, and a lot of them are not aware of it. I know our board does participate and uses NASBA's communications efforts to a good extent, so that's good to see.
Are there other updates? And I think the only AICPA committee we have is Peak. Is that correct? So, and Andy, you've given that report. Okay. Thanks, everyone, for your participation with that. And at this time, I would call on Lee Lott to give us a legislative update.
Yes, sir, just briefly, the legislature is still, the General Assembly is still filing bills. We get a new batch of bills every day. There is a bill that has been filed that relates to accountancy. It's House Bill 400, Senate Bill 277, and it is what's called a caption bill, which means the caption of the bill is very broad. It says that there may be an amendment to the law under either Title IV, which is state government, or Chapter 1 of Title 62, which is accountancy. It's like and/or. And it doesn't give any further specifics in the caption. Now, the body, as it's currently drafted, the body of the bill says that there will be, that what is proposed in the bill is a change to the examination subjects for the CPA exam. And I have no feeling whether that's a major issue or a minor issue. You on the board would definitely have a feel for that, but it would be to change the subjects from business law and taxation to taxation and regulation. But that's just the current language of the bill as it's drafted right this minute. At any minute, there could be an amendment, and it could be a substantial amendment that is totally off topic from the CPA exam. It could concern anything under the topics of the caption, state government or accountancy. So we're watching that, and we're also watching for any other bills that may come along.
Thank you, Mr. Lott. I think we need to watch that closely because currently, as you know, we have a uniform CPA exam, and so I think we have to be careful about tinkering with the exam because we really don't control that. Is that correct? Yeah. So, thank you for that update. Anything else?
No, sir.
Okay, thank you.
Question
Yes,
for
sir.
Mr. Lott. What's the last day that new bills can be presented, Mr. Lott?
The 9th, Thursday.
Thursday? Okay. Thank you.
But yeah, an amendment's going to occur after that. So we're watching new bills being filed every single day right now. But even after Thursday, there could be an amendment to any one of these bills, including something as broad as this one I identified.
Thank you, Mr. Lott. At this time, I would ask Kara Fitzgerald, who's CEO of the Tennessee Society of CPAs, to give us an update. Kara, welcome.
Thank you, Chairman Gilbert. I appreciate the invitation to speak to you all today. Members of the board, I was specifically asked to provide an update on the current status of licensure across the country. Of course, you all have already had an in-depth conversation about that today. I'll preface my comments by saying I'm not familiar with the map that was referred to. I'm not familiar with the 17 states. So some of the information that I present may be slightly different. I was in a meeting with Dan Dustin and John Johnson from NASBA in early January. At that point, there were 6 states who we knew had filed legislation. I know of about 11 today, so apparently there's been other changes that I'm not aware of. NASBA does not share that information with the state CPA societies, and so Andy may have more to be able to add to the information that I'm going to provide to you today. Before I get started, I think we can all recognize that Minnesota really kind of led the way by introducing legislation in 2023 that proposed alternative pathways to licensure. And while that legislation has not passed in Minnesota, their bold steps and leadership set the stage for many necessary conversations about the future of CPA licensure. And I will point out that I believe it also highlighted that we are far less substantially equivalent than we once thought that we were. I've been a part of countless meetings and conversations focused on licensure, and there is generally agreement that additional pathways to CPA licensure are needed to reduce barriers created by the time and cost of the additional educational requirements, to provide flexibility and options for those pursuing licensure while maintaining rigorous standards and protection of the public interest. Now, as has been already pointed out today, that looks very different depending on the state and the discussions that are being had. Nationally, various aspects of licensure are being discussed by both state CPA societies and state boards of accountancy. Some states are adding additional pathways. We'll talk more about that in a moment. Some are replacing references to credit hours, as was mentioned earlier, and instead referring to the types of degrees that are required. And then also many states are considering automatic mobility with various guardrails as a means to address the changes that we now know are inevitable to happen. We want to protect our practice privilege of mobility, and many believe that automatic mobility is the means to be able to keep that practice privilege. Each state's approach looks a little different, but for those states that have introduced legislation, there are many similarities, and I will try to highlight some of those today. As you likely know, Ohio made headlines earlier in January when the governor signed House Bill 238 into law on January 8th. Ohio's legislation will allow qualified CPAs from out of state to work in Ohio. According to the bill, an individual whose principal place of business is in the state of Ohio shall have all of the practice privileges of a holder of a CPA certificate and an Ohio permit without the need to obtain a CPA certificate and an Ohio permit. You have to have all of the following for that provision to apply. You have to hold a valid CPA license in your home state. Again, this is for CPAs who do not have a principal place of business in Ohio. You have to have obtained a bachelor's or a higher degree. You have to have completed an educational program with an accounting concentration, and you have to have passed all parts of the CPA exam. So when we refer to automatic mobility with guardrails, those are the types of guardrails that are being considered by many states and what has been adopted in Ohio. In addition to that provision in the law in Ohio, effective January 1st, 2026, two pathways will exist for CPA licensure. The first will be a master's degree completed with the required accounting concentration of coursework, plus 1 year of experience, plus passage of the CPA exam. The second pathway will be a bachelor's degree completing the required accounting concentration of coursework and 2 years of experience, plus passing the CPA exam. I want to point out in Ohio's law, the effective date is January 1st, 2026, and that's been a topic of many conversations I've been a part of to address some of what's been discussed today, is that any law change, no matter the state, will likely require academia to potentially make adjustments to curriculum. And so by having those effective dates into the future, hopefully provides a runway for educational institutions to be able to make those adjustments. As I stated, I'm only aware of about 10 states that have active legislation currently. Would love to know additional ones so I can add those to my list, but I'll just very quickly go through the highlights of those that I am aware of. Some are looking at additional pathways plus automatic mobility. Some are just looking at one or the other. Utah is removing the hours requirement. They're adding a requirement that applicants for CPA license have a bachelor's degree with an accounting and business concentration, and they are also removing references to substantial equivalency. In Indiana, they have a proposal to create 3 pathways, much like we've talked about earlier: bachelor's degree with a concentration in accounting, a bachelor's degree with a concentration in accounting totaling 150 hours, or a post-baccalaureate degree with a concentration in accounting. I want to point out, using this Indiana bill as an example, that concentration accounting, it seems to be critically important to ensuring that candidates for licensure are obtaining the needed accounting education to be successful on the exam and successful in their careers as CPAs. Also in Indiana, they're replacing 1 year of experience requirement that currently exists, and they're aligning again the experience with the type of degree. So 2 years if the individual has a bachelor's degree, 1 year of experience if the individual has a bachelor's degree with 150 hours, or if they have a master's degree. The Indiana legislation is not addressing mobility at this time. Virginia is proposing to remove references to substantially equivalent. They are proposing automatic mobility. And then after January 1st, 2026, proposing education requirement changes that would allow for a bachelor's or higher degree with an accounting concentration, and again, aligning the experience requirements with the type of degree. Florida, very similar, proposing 3-pass, adjusting the experience requirements to align, and then also proposing automatic mobility with guardrails. Georgia, again, very similar, proposing 3 pathways and automatic mobility. Texas, much of the same, proposing 3 pathways and automatic mobility. Minnesota is going to be reintroducing legislation in 2025. I have not seen their specific bill yet. South Carolina has legislation that is filed. Maryland has a bill that's currently been filed advocating for automatic mobility, and Oregon has recently filed a bill that would create additional pathways. So again, while all somewhat different, all kind of aligning around this concept of creating additional pathways that are focused on the types of degrees and less about hours, and a lot of support around this concept of automatic mobility. When Katie Cheek presented to this board in October, I believe that she mentioned that our chair, Kelly Crow, had formed a task force to address a couple of different things. One, to review the 2 exposure drafts that had been released by AICPA and NASBA, and to formulate a response to those exposure drafts. The task force was also charged with looking at kind of the national landscape, similar to what I just went through, and determining or making recommendations to the TSCPA board, and then also looking at automatic mobility. The task force did review in depth. They spent 3 meetings over about a total of 9 hours in meetings doing all of this work. So the first step was to respond to the exposure drafts. TSCPA did submit a comment letter in response to both the competency-based experience pathway exposure draft and the UAA amendments. And our comments, from what I have heard, aligned pretty well with probably the global comments. I won't go into a great discussion on that, as it sounds like we're not moving forward with the competency-based experience pathway at this time. The majority of the task force time meeting was spent on looking at the national landscape, looking at the history of the 150-hour requirements, digging into educational requirements at various educational institutions in Tennessee, and then looking at mobility. Armed with the knowledge that many states are pursuing changes, the task force quickly recognized that the practice privilege of mobility is critically important to our profession and to our licensees in Tennessee, and they agree that automatic mobility is one solution to preserve that practice privilege. Currently, I think Andy mentioned this, 4 states have automatic mobility: Nevada, North Dakota, North Carolina, and Alabama. In my discussions with those states, they've had that privilege for many years and have not experienced issues or concerns around public protection. Under automatic mobility, practice privileges across state borders will not rely on a determination of substantial equivalency, but will instead be rooted in the passage of the universal CPA examination. And as I mentioned earlier, some states are adding additional guardrails, such as the type of degree. I think Mr. Monroe mentioned that as being important, or potentially even years of experience. But our task force did recognize that automatic mobility seemed like a reasonable solution and made that recommendation to our board of directors. The task force also recognized that any change to licensure must protect the public interest, preserve the State Board of Accountancy's ability to control discipline for the practice of accounting, maintain the CPA exam as the capstone for licensure, and maintain the high degree of professional competency expected from CPAs. Ultimately, the task force coalesced around broadening the pathway to licensure to offer options and flexibility based upon each candidate's individual circumstances. And that recommendation that the task force made to our board of directors was for 3 pathways: a bachelor's degree plus a master's degree plus 1 year of experience plus the exam, a bachelor's degree plus an additional 30 hours plus 1 year of experience plus the CPA exam, and a bachelor's degree plus 2 years of experience plus passage of the CPA exam. And those recommendations were sent to TSCPA's board of directors for review and consideration. The rationale behind supporting both automatic mobility and additional pathways involves, again, providing flexibility, reducing barriers, promoting workforce development, and creating a good environment for Tennessee business and the economy. As it relates to mobility, strengthening interstate mobility provides for clarity and certainty in a time when we may lack clarity and certainty related to licensure requirements. It keeps the exam as a capstone, and it will allow Tennessee to continue to attract top talent in our profession. So with that, I am happy to answer any questions that provide you kind of where TSCPA has been focused and the recommendations coming out of our task force.
Karen, just appreciate very much the synopsis as well as the communication that the society's had, not only with our board, but with all of our practitioners that are members of the society. The question I would have is still around automatic mobility. I guess you could say what the society seems to be advocating for is automatic mobility, but with guardrails around education requirements and experience and the exam. And I'm struggling, the way that I've heard it explained is that, that kind of puts the onus on the individual versus a state-by-state determination of substantial equivalency, which is really the environment that we've had. And I guess I'm still struggling to try to find the substantive difference between substantial equivalency as we define it in our state and automatic mobility with guardrails. I don't see, other than the semantical difference, I don't see much difference there. Is that something differently? Does the TSCPA approach it differently?
The way that I look at that, Kevin, is right now substantially equivalent is defined as 150 hours. And so as we see movement across the country to provide alternative pathways that may not be 150 hours, automatic mobility provides a pathway for us to continue practicing via mobility. Whereas if, I think Tennessee, and I don't want to speak out of turn here, but I believe Tennessee is a state that NQUAS has determined is substantially equivalent. And there's a list of several states. So if that definition stays, substantially equivalent means 150 hours, suddenly we are not going to be able to enjoy, those states who enact changes would not be able to enjoy the practice privilege of mobility if we're sticking just to that definition.
Understand and appreciate that clarification.
And I do appreciate what you coming forth today and kind of sharing, and appreciate all the efforts the Tennessee Society is making. The task force has been wonderful, and I know that this is a challenging thing across our profession as a nation right now. So thank you for coming today and presenting that. When we talk about automatic mobility, are we as Tennessee giving something up? In other words, since it doesn't sound like we're going to say with rigor or automatic mobility subject to this, are we just going to accept any state that says you're a CPA and welcome into Tennessee, regardless of what their qualifications are?
Mr. Bonner, I can't state what we are going to accept or not because there's not been automatic mobility enacted. So until we move forward and see specific legislation, I don't know that I can speak to that.
I think the intent of the task force was to create a pathway for us to continue to practice mobility using passage of the CPA exam as the primary requirement for individuals to be able to practice in Tennessee. That was the viewpoint of the task force. I can't speak specifically as to how that will end up, as there's no legislation at this time.
I noticed that when you were talking about it, you said with a concentration in accounting. Do you foresee that, did the task force like the idea of having in there not only just the passage of the exam, but also a concentration of accounting as far as courses?
We spoke a great deal, the task force spoke a great deal about the accounting concentration that I believe is currently defined in this board's rule, and there was no discussion or intent in, advocating for change in that. That would obviously be up to this board, but the task force felt it was very important to ensure that body of accounting education is maintained, but that would be up to the board in determining how that rule moves forward if there is change.
What I know right now, and from my meetings, that California, not to use them, but other states also are defining what experience is, and they're actually adding some rigor to it at the board level. Did y'all consider that, or what do you think about that aspect of it, whether the board may have a decision to say, hey, it's automatic mobility, but these are the things that we look for. We look for maybe the concentration in accounting with specific courses. I know that California actually has specific courses listed that they look for.
The task force did not talk about, related to automatic mobility, did not talk about specific experience requirements as it would relate to determinations that the board would make.
Okay. Thank you.
I do have a question, and it's less for Ms. Fitzgerald, but I appreciate your comments. It's maybe more for the legal team, since I'll still consider myself the gumshoe here, the newest guy on the board. But again, notwithstanding the comments and the perspectives of individuals that we may hold as practitioners or personally, it's still not clear what our role as board members is in this regard. And that's my clarification. It seems to me, and correct me if I'm wrong, that if a change in statute is going to occur, regardless of where the genesis of that change comes from, whether or not it's the CPAs or somebody else's view, that comes through the legislative process, correct? Which is something that the legislature takes up, obviously I'm guessing in conjunction with the governor's office. And then once a law is passed, if a law is passed, then it's our job, depending on how the law is written, to enforce said legislation, right? So, okay, I just want to make clear that there's not an action for us as a board to take. This is just informative for us as a board to understand the landscape as it may be changing, obviously to share our perspectives. But from a oversight perspective, there's nothing for us to do currently.
That's correct.
Okay, thank you.
The only thing is, we were asked to provide comments to NASBA and the CPA, and we did that. But yeah, we're not really part of the legislative process, but this is just update information.
Sure, yeah, okay.
Comment.
Sure.
Following up on your remark about concentration in accounting, I do like the way we have that laid out, and we went through much deliberation to get there. I know other states have had different lists, sometimes quite different. For example, Texas had a Texas ethics requirement or something like that. Did you get a feel for whether states are looking to the universities to define the concentration in accounting, or the boards, or, are they, when they do mobility, are they accepting whatever the other state did? That could be a sticking point, I think. But also, I am concerned that people be able to take a degree in anything, I hope they can, and pick up that concentration in accounting, perhaps later, perhaps in addition to their degree. That's been an important part, I think, of the 150-hour model.
Dr. Church, I'm not sure that I've heard in the discussions I've been a part of, a lot of discussion around the accounting concentration. I've seen accounting concentration referenced in the bills, but not defined. And so I suspect that's often done in board rule as it is in our state. I think that highlights just another example of how we have had differences yet been deemed substantially equivalent because the accounting concentration has been different. And so this is not introducing any new change potentially there. All I can say is that from what I have seen in the bills that have been introduced, there does appear to be a desire to maintain that accounting concentration and a recognition of the importance of that.
Okay, thank you.
Any other comments or questions? Kara, thank you very much for taking the time to be here with us today and present. And we are very appreciative of the relationship that the Board of Accountancy has with the TSCPA, and you certainly have helped foster that, and we are very appreciative. It benefits not only this board and the TSCPA, but I think it benefits all Tennesseans, whether they're CPAs or the public being protected by the Board of Accountancy. So thank you for all of your efforts
Thank you for having me.
in that respect. And also thank you for the task force and the work that it's done, and especially for allowing Assistant Commissioner Reed Witcher to sit in on the task force hearings. Again, I think that's great. That shows the relationship that we have in Tennessee, and that we're all shooting kind of for the same target. So thank you very much. Reed, thank you for participating on the task force too. At this time, we will go to the new business section of our agenda. I'm not aware of any new business, but Jen, no? Okay. And then we will go to the public comments section. Karen, anyone online?
No, sir, not online, and no one has signed in for a public comment.
Okay, very good. So I believe that concludes our business today, and the chair will entertain a motion to adjourn.
So moved.
So moved. Second? Good. Thank you, everyone. Jen, thank you.